Hello, good morning. My name is Jamal Khan. I'm the head of tax at Churchill Tax Advisors. It's our Monday morning tax update. Today's the 15th of July 2019, and I will try to make this update more interesting than the World Cup yesterday. So we'll cover the cases that have been announced in the last week or so by the First Year Tax Tribunal. The first case was Perfectos Printing Inks Limited versus HMRC. Now, this case was brought to the tribunal by the taxpayers because the HMRC had been inquiring into the tax returns for 3 years and they have not found anything. Clearly, the taxpayers, tax advisors and the taxpayer had enough, so they wrote to the tribunal for the inquiries to be closed. The HMRC objected to this appeal, but the judge found that the taxpayers had fully cooperated with HMRC. They had provided all the pieces of information that they had asked for. There was no reason to suspect that there was any fraudulent behaviour by the advisors or the taxpayer. This is quite an important case. Now, the judge decided, Judge Asif Malik, he said that yes, if there was any doubt, any reason to doubt the taxpayer or the advisors or the documents that had been delivered, which HMRC didn't have any reason, therefore the judge gave an order for HMRC to close the investigation within 6 months. This gave them enough time to conclude inquiries, but it was unreasonable for HMRC to carry on. And this is a very important case from my perspective because when we deal with cases, and we have done this several times and we've been successful, is when HMRC are dragging on cases without any basis or reason to suspect. We cannot let them drag on the case for months and months and years and years, because it puts the people under investigation under significant stress, and it can kill you slowly, as they say. So people should know their rights, that you cannot allow HMRC to continue indefinitely if there's no tax to pay. The next case is for Inverclyde Property Renovations LLP versus HMRC. Now, this is from my perspective, this is the most interesting case of the day or of the week. Basically, HMRC started an investigation into an LLP's tax return under the income tax principles. Now, the advisor that was appointed by the LLP was fairly clever, I would say. What they did was they challenged, after all the deadlines had passed, they challenged the basis of the assessments or the investigation, the sections that HMRC had applied were incorrect. They said that their argument to the appeal to the tribunal was that HMRC used the wrong provision, the wrong legislation when opening their inquiry. They should have applied the corporation taxes legislation rather than the income tax, because an LLP is a body corporate in a way. It has limited liability. The judge agreed with the appellants and the advisor's position and said to HMRC, you cannot investigate using these powers. But at the same time, the HMRC were out of time to use the corporation tax provisions. So this appeal effectively nullified HMRC's assessments or position completely altogether. I think this is a very good, well-planned approach, and HMRC will no doubt have to reconsider how they conduct investigations into LLPs going forward. They should consider, because they've lost a very big case there. The next one is Gray versus HMRC. Now, this case is interesting, that the client had incurred roughly £900,000 of legal costs in a shareholder battle. He was a minority shareholder and was not getting the right dividends, etc., the rights, and therefore they took the majority shareholders to court, spent £975,000. Some of the areas they were successful, some of the areas they were not, but then there were some other areas involved as well that were not outside of this dispute. So the HMRC disallowed the legal costs. Now, the matter went to court. The judge looked at the costs that were incurred. The judge, these are legal costs that are outside of your trading purposes, therefore that you cannot claim these costs. I'm surprised that that this appellant took the case to the court, because if it had come to us, we would have advised our client that there was very little chance of this case or this appeal being successful. So the client effectively, the taxpayer effectively spent £975,000 in the legal costs, and probably another £40,000-50,000 paying counsel or tax advisors to represent them in court, and they lost everything. Our advice would have been completely different. Now, the last case for today is one of my favourites once again. It's about Marks and Spencer versus HMRC. Now, in this case, HMRC raised VAT assessments on Marks and Spencer for £10 meal deals. So if you go to Marks and Spencer sometimes in the evening time, you can see you can buy a main course, a dessert, a salad, plus a bottle of wine for £10. So what they say is you buy these 3 items and you can any 3 items and you get a bottle of wine for free. So HMRC, then Marks and Spencer then filed their VAT returns on the basis that because the bottle of wine was given free, there should be no VAT on it. HMRC objected to that. And they said, no, you should charge VAT because it's part of a meal deal, so that there should be a value appointed, allocated to the wine bottles. It went to court. The judges looked at it, and then the judges said, actually, this is part of same as buy 2 get 1 free. Even if you call it's free, it's not actually free. It's a combined cost. It's a combined price that they pay. So even if they say it's free, it's not actually free. HMRC have won this case, and Marks and Spencer obviously, this is another case that Marks and Spencer have lost. Marks and Spencer have been in the tax courts for many years, in and out of different cases of arguments, but this one was quite unique, and I think from my perspective, the way I look at it is fine. HMRC have won and Marks and Spencer have lost, but how would Marks and Spencer get around it? This problem. What is there to stop Marks and Spencer to say we could potentially buy a £10 meal deal and get a bottle of wine for 50p, or say £1, and put a value on it? And that could potentially change a lot. This case could turn around in Marks and Spencer's favour. If they had done that, this case would have never gone to the tribunal, because there is a value of £1 or 50p on the wine bottle. Therefore, it cannot be challenged as anything else, or free, or a bigger value. So there's something that Marks and Spencer could potentially think of, but maybe there are more details to the case that we don't know. But on the face of it, this is the summary for this case. If you have any questions, or if you have any tax questions on tax planning or tax investigations, please get in touch with us. Telephone number is 0207 998 1834. And if you like our publications, our videos, please do this. Thank you. Bye.